chaos erupts in the courtroom. Pleas, probation violations, and shocking confessions all collide. You won't believe what happens next.
Good morning. Are you Federico Ortiz? Yes. And will your client waive the formal reading of the motion and the indictment?
Yeah.
Mr. Ortiz, in clause number 25, DCCR 0589, you're charged with the state jail felony offense of abandoning.
Hold up, everyone. Notice how the judge is meticulously confirming that Mr. Ortiz is pleading guilty freely and voluntarily. This is a crucial safeguard. Courts have to make sure no one is coerced. And it also sets the stage for how appeal rights can be limited later. Quick audience check. How many of you knew that a guilty plea could affect your immigration status? This is legal drama with real-world stakes.
Abandoning or endangering a child, and that's from December 1st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you? In that case, I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you sign these, did you go over them with Mr. Rojas? Do you fully understand? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Okay.
It's admitted. Is there any evidence that Mr. Ortiz is not competent?
No.
All right, sir. In that case, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time...
Here comes the probation twist. Mr. Ortiz isn't just dealing with one case. This is probation revocation territory, meaning misreporting or community service violations can dramatically increase sentencing. Imagine thinking your probation is routine, and suddenly it's hanging over you like a ticking clock.
Find you guilty of the state jail felony offense of abandoning or endangering a child. Sentence you in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then, 24 DCCR 2334. I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation April 10th, 2025 for the offense of burglary of a habitation. And that was a 5-year deferred probation. Is that correct? The motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department for the months of May and June of 2025, and then also July of 2025. Is this true or not true? And then count 2 alleges that you failed to provide verification of performing the community services required. Is that true or not true? Then count 3 alleges that you failed to provide verification of completing the theft prevention plans as ordered. Is that true or not true? And then finally, count 4 alleges that you're behind in your court-assessed fees. And is that true or not? Did you enter your pleas of true to counts 1 through 4 freely and voluntarily? And did you plead true to those counts because they're actually true? I also have here on the tablet, in this case, some documents that have your signature on them that the state's marked as Exhibit Number 1. Did you also go over this with Mr. Rojas?
Yes.
And do you fully understand? State tenders number 1?
Okay.
It's admitted. Mr. Ortiz, I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily.
Legal nugget alert. The judge just went over firearm restrictions. This isn't just courtroom filler. Violating these restrictions can result in new felony charges. Think about it. One wrong move outside these walls could land someone back in serious trouble. Audience poll. Did you know state laws vary on what counts as a firearm? Drop your guesses below.
That you're mentally competent to understand the nature and the consequences of those pleas. Find sufficient evidence at this time to find you guilty, and at this time find you guilty of burglary of a habitation. Sentence you in accordance with your agreement to a term of 3 years in the Institutional Division of the Texas Department of Corrections, You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In each of these cases, I'm handing you the trial court certification that shows that there are agreements that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rowe. Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.
Thank you. Randolph Vines, Mr. Rojas. Mr. Rojas is getting a gold star this morning.
Gonna walk.
Oh, well, I might have this shirt.
I'll take a walk.
Good morning. Are you Randolph Vines?
Yes,
And will your client waive the formal reading of the indictment?
ma'am.
Mr. Vines, in cause number 25 DCCR 1154, the state has elected to proceed on count one only, and in that count to the lesser included offense of a Class A misdemeanor, unlawful carrying a weapon, from June 29th of 2025. And how do you plead to that charge? And are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you sign these, did you go over them with Mr. Rojas? Do you fully understand? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And are you a U.S. citizen?
Yes, ma'am.
State tenders number 1.
Okay.
It's admitted. Is there any evidence that Mr. Vines is incompetent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of unlawful carrying a weapon, sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I feel like this might be one. I don't know all the misdemeanors, but I feel like this is one. Yeah. So I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You obviously know this based on what you're charged with, and I'm required to read it. Now I forgot what it was. But if you have any questions about what, you should read the document I provided you. I lost it totally. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk with Mr. Rojas. You can go back with the bailiff. That's what I get for not reading it. I'm reading it in my head. I don't even know where my copy of it is anymore. I've read it, said it to me. But I can't stop in the middle and then restart. That's not good. Lamone Yeoman, Mr. Rojas. Give me just a second. I'm going to print these out. They're both MTRPs, and it's just easier. Good morning. Are you Lamone Yeoman Jr.?
Good enough.
And will your client waive the formal reading of the motion in each case?
You will, Your Honor.
Should have another one coming in. Okay. Mr. Yeoman, in clause number 19-32846, I have a first amended motion to revoke your unadjudicated probation. It shows that you were placed on probation November 12, 2019 for the offense of aggravated assault with a deadly weapon, and that was a 10-year deferred probation. Is that correct? And then in clause number 23, DCCR 1556, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation July 17th of 2024 for the state jail felony offense of burglary of a building, and that was a 2-year term in state jail prison that was probated for 5 years. Is that correct?
Now we hit high stakes with Mr. Iman Jr. multiple probation violations, including alleged drug distribution. This section shows how layered probation violations can get. Some counts are true, others denied. For viewers, take note. The system is designed to separate fact from allegation, and judges have to navigate a maze of claims before issuing a sentence.
Each of these cases allege that you violated your probation. Count 1 in each case alleges that you failed to avoid persons or places of disreputable or harmful character, and specifically avoid association with any person previously convicted of a crime, or be present at a location where a criminal act is committed, in that you were supplying other residents of the Cheyenne Center with K2 synthetic marijuana. And is that true or not true? Okay. Count 2 in each case alleges that you failed to report to the probation office as directed April 2nd and April 3rd of 2025. And is that true or not true? Count 3 in both cases allege that you possessed a drug, K2, on or about March 30th of 2025 in violation of your order. Is that true or not true? Not true? Okay. Count 4 alleges that you failed to successfully complete the safety program as directed. Is that true or not true?
True.
Count 5 in each case alleges that you committed the new offense, possession of a controlled substance, penalty group 1, August 8th of 2025. And is that true or not true? Count 6 in each case alleges that you committed the offense of possession of a firearm by a felon, August 8th of 2025. And is that true or not true?
Not true.
Count 7 in each case alleges that you failed to report to the probation department April 11th, April 21st, April 30th, May 9th, June 6th, and July 7th of 2025. And is that true or not true? Did you enter your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily? And did you plead true to those counts because they're actually true? In each of your cases, I have here on the computer some documents that have your signature on them that states marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand that? And do you understand think y'all did the paperwork backwards.
We did originally do it. We probably did. It
So,
was a chapter 8 on 19-32846 and chapter 3 on 328
well, it's, hold on. Anna, can you send me back 23-1556? I just sent it.
Yeah, maybe the 33-46.
Yeah. Okay. I think, so 23-1556 is the burglary of a building, but y'all did TDC paperwork. And the other one, yeah. So,
Miss Harmon's case highlights recidivism and electronic monitoring. When prior convictions come into play, the stakes skyrocket. Each prior felony can impact sentencing guidelines. Audience engagement. Think about the balance here. How much should past offenses influence current sentencing? Drop your thoughts below.
those have to be right. So let's,
You can read it.
I'm going to delete both of those.
Sound good.
I'll just hold this. We'll continue the hearing. I'm not going to go back over everything. We'll just go over the paperwork as soon as it comes through. And did y'all do it twice?
We did. I got numbers on it. We did it.
Okay.
We're doing it.
Sorry.
Okay, that's fine.
I'm going to delete this. All right, y'all just go have a seat in the jury box and we'll get that. I was looking and I was like, wait a minute, that's because I thought it was a CAFA 2 on the TDC case. I'm like, what? Okay.
Yeah. Yeah, so we'll talk to you too. We'll talk to you.
Okay.
You want to say something now, or do you want to do? We'll do it.
Go ahead and get that one done. That way I don't keep this over here and get confused for too long, and I'll take care of a couple other things. Mr. Kindler, you have Sheena Harmon. Yeah, which one? Okay, take care of it next. Would y'all put that Christopher James thing up here for me to do next, please?
Here's the key takeaway. Every courtroom moment, pleas, motions, probation revocations, has ripple effects. For viewers, it's like watching a legal chess game, where every move counts. Remember, the courtroom isn't just rules, it's strategy, consequence, and sometimes raw human drama.